Welcome once again to Lehto's Law. Here's Steve Lehto.
Bill and a lot of other people sent me this story. I have covered this story before. It is a crazy story, but it is just slogging on like a zombie. This case will never end, apparently. And I got to tap dance around a few things because, as you know, this show is G-rated. Okay, so I have to be very careful about them adult topics. Things that people do when they want to get more acquainted in private. Eighth Circuit considers whether auto insurance extends to STDs in cars. Dave Burns wrote this for CourthouseNews.com, widely reported. I saw a version of this on Fox News. I saw versions of this elsewhere. I'm going with this one because I think this is a more level approach to it. An appellate panel of the Eighth Circuit convened on Wednesday to hear arguments over an uncommon question. Could you claim insurance benefits for catching an STD from something you did in your car? A Missouri woman who uses initials because it's embarrassing thinks so. Back in 2021, she sent her insurance company a $1 million bodily injury claim after her partner, who has a policy with the insurance company, infected her with HPV in his 2014 Hyundai Genesis. Right now, as guys out there with Hyundai Genesis is going, really? Chick magnet? But the couple hadn't taken steps to protect themselves. And the insurance company denied that they were on the hook for this financially. The District Court of Western Missouri agreed with the insurance company. And so the insurance company had to bring the issue to the federal court back in 2021. And in March of 2023, the district court decided the case in the insurance company's favor. And I'm not going to get into it, but there's a whole rigmarole where the people involved were trying to keep this out of the courts and somehow get a judgment against the insurance company and then try to get that entered into court. But the judge wrote, upon review of the parties' arguments, the court finds that consensual relations inside a car do not constitute a use of the automobile within the meaning of the subject policy. And I did drop a word out of there between consensual and relations. You can figure that out. The couple wasn't satisfied. She and her partner brought the case before the Eighth Circuit, hoping to have the case sent back to the district court for further proceedings in their favor. In both Wednesday's oral arguments and in the briefs, the couple argued that the infection, which subsequently led to the woman developing cancer, was sufficiently connected to the use of a car and its insured owner to justify an insurance award. The woman cited how her partner had never told her that he was infected, and how a Missouri arbitrator also found that he owed her $5.2 million for negligence. And so keep in mind that if you're involved in a car accident, in most states, you get sued, and then you tender the suit to your insurance company and ask them to defend you. And they then will pick up the defense and defend you, and then if a judgment or an amount is owed, then they're on the hook for whatever their coverage limits are. It's going to change a little bit from state to state. So you don't actually, in essence, sue the insurance company. You sue the insured, who then turns it over to the insurance company. And there's some allegations here about how these two handled the initial claim and whether or not the insurance company had the ability to step in and defend the claim in the first part of this. So according to this is what the couple wrote in their appellate brief. They engaged in activity in the car at least once as of December 2017. Plaintiff claims the defendant negligently failed to tell her that he was infected with HPV and failed to use adequate protection and take proper precautions to prevent its transmission to her. Under the auto policy, bodily injury means bodily injury to a person, including resulting sickness, disease, or death. Now, even if the insurance company's policy is unclear on the specific issue, they argue they were still entitled to benefits. The policy was issued in Kansas, and under Kansas law, contractual ambiguity is generally decided in favor of the insureds. And that's true in many states. Ambiguity is often construed against the drafter of the document. If the policy is ambiguous, Kansas law requires it to be interpreted in favor of the plaintiff and for coverage. Under that circumstance, the policy would again provide coverage, the pair argued in their briefs. Now, the argument sparked debate on the appellate panel Wednesday as a circuit judge, three of them actually, wondered just how far this line of logic could extend. Would a decision, for instance, in favor of the plaintiff here mean that the insurance company is responsible for unwanted pregnancies? And now, the attorney for the plaintiff said, I don't believe that's a cause of action. That's a good question, but pointed out that a pregnancy might not be a bodily injury in the same sense that a disease is. So the insurance company, in its own arguments, made an appeal to normal use of a car. The company's attorney argued the insurance policy should only apply when using an auto as an auto for vehicular purposes. Company's brief similarly pointed to prior Kansas court rulings that denied coverage to people whose injuries were only tangentially related to cars. This specifically is a basis for why sheltering in an auto, or the fact that the injury merely occurred in an auto, is insufficient under all of the Kansas cases. So this argument also seemed to frustrate the appellate panel as it made an appeal to an unquantifiable appropriate way to use a car. The panel argued that people use cars in various ways for any purposes, including as a place to get intimate. So the insurance company says that if they grant the relief here, insurance benefits would fundamentally change the intent of the policy. You're turning what is an automobile policy into a general liability policy without restriction. The appellate panel took the case under consideration, but did not say when they would deliver a ruling. And as many people have pointed out, and I actually get this a lot, where people will send me this link with one question. And they say, Steve, if this goes through, doesn't that mean that if you caught it in a house, you can go for the homeowner's policy? One might think that'd be a logical argument. And likewise, let's suppose I'm driving down the street and I'm having an argument with somebody and I reach over and I clunk them. Can they file a claim with my insurance company? Because one might assume that you might have an argument in a car. And so it is an interesting thought exercise. I would have to imagine that they're going to come back and go, no, the insurance doesn't cover this. But the weird part is, and many people have not done this, is find a copy of your policy and read it and look at it from the viewpoint of the insurance company. I know it's hard. But you're looking at it and you're asking yourself, why is it worded this way? And you realize, they're trying to explain what they're covering. So they'll go, this is a policy of insurance. It's an agreement between us and you. Us is defined as the insurance company. You is defined as and you go, this is crazy. No, because they've got to spell this stuff out. And somewhere buried deep in the heart of the policy is language that says what is covered. And it'll say that, they cover injury that arises from the normal operation of an automobile. And that presumably might be the car is involved in a car crash. That's normal operation, right? But again, the car is parked. People are in it. And they're doing something a lot of people do in cars, but is the car really designed for that? Before you say yes, I'm not familiar exactly with the 2014 Hyundai Genesis. But the question is, how much room is there in that car? But be that as it may, the line has got to get drawn somewhere. You can't say it covers every single thing that happens in or around this car. And you might go, Steve, where'd the word around come from? Oh, I remember a case in Michigan where somebody swung the door open, went to step outside, stepped on something, slipped and fell. And where they slipped and fell had no insurance. So they said, okay, I'm going to go with my car owner insurance then, because I was getting out of my car. And the question then becomes, does the insurance have to cover you as you get into or out of your car? The same way it protects you when you're inside the car, something happens to the car with you in it. And so what's bizarre, and I can tell you this as an attorney practicing law now for 33 years in the state of Michigan, is there are different organizations that publish stories and cases about the law. And this story here is from Courthouse News. But there are also sites that cover stuff like in Michigan. Michigan Lawyers Weekly is a newspaper that comes out weekly. It's aimed at lawyers in Michigan. And that's why it's such a great name, Michigan Lawyers Weekly. And they cover whatever the newest, latest case law is, where things are happening on the cutting edge of the law. And I'm not making this up. it seems that every single issue has an article about a recent case interpreting the cutting edge of what's covered and not covered by automobile insurance. And that's because it's so hard to imagine every single possibility. And you might say, but Steve, I can imagine this possibility. Yes, you can. And here we are in 2024 talking about it because it is a novel issue as far as I know. The incident is alleged to have taken place in 2017. And as you might guess, that's more than 100 years after the automobile became a thing you might see on the road commonly. So it took 100 years to get to this point. So yes, new questions pop up all the time. Now, this one, if I had to guess, I would think that they're going to come down on the side of the insurance company and go, yeah, this does not extend to every single little thing that can happen in your car. But on the other hand, they might go, gee, the way your policy is written, I can understand why people might think that would be covered. Maybe you need to tweak your policy. And would it hurt them to put a line and say, by the way, things we do not cover and include this? Wouldn't hurt them. I can't imagine someone going, gee, I was going to buy your insurance until I saw that you excluded that. So we'll see what happens. But I've done at least 2 or 3 videos previously on this. And again, we thought it was over, but no. So it's up on appeal at the 8th Circuit, who is considering whether auto insurance extends to things you caught in your car while getting to know someone better. Dave Behrens wrote that for thecourthousenews.com. And Bill and a whole bunch of other people sent it. Thanks a lot. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Letting the cat out of the bag is a whole lot easier than putting it back in.